Judge President, you are still under oath.
Thank you for the reminder, Chairperson.
10 July 2025, proceeding with the matter of Mango and Mbenenge. Advocate Skippers.
Thank you, Chair. We have spent a lot of time before this panel looking through all the WhatsApp exchanges as sent between yourself and the complainant. It is correct that
Sorry, Advocate Skippers, could you afford me the opportunity to deal with a matter that I interacted with you on late yesterday and early this morning?
You can do it now, or you can do it when I deal with that specific part when I ask questions, but you are welcome to deal
with it now. Thank you. With your indulgence,
Yes.
Chairperson and
Yes,
honorable members, shall I refer to the consolidated bundle, volume 21? Sorry, consolidated bundle, which is the bundle that we were using, page 21.
Small 21.
Small 21, yes. I'm referring to paragraph 19. Paragraph 19 has got sub-paragraphs, but they are not numbered. I'm particularly referring to the last sub-paragraph, which is not numbered, of course. That paragraph, and I think it's best for me to quote it. It says, and I quote, from 31 May 2022, JP made a comment in person pertaining my work dress code and work ethics, which made me uncomfortable. I ignored him and I kept on sharing everything with my former judge who has now retired, close quote. So there's a reference to 31 May 2022 as a date on which I meted out the conduct referred to in that particular paragraph. Then yesterday I made reference to a case. There are copies, I trust, that have been shared with the panel of the judgment concerned, in relation to which I would like to make a point. A sequel to the exchanges and the cross-examination of yesterday. The judgment is placed before the chairperson and the honorable members, am I correct? His judgment in sustaining the Wild Coast NPC and others versus Minister of Mineral Resources and Energy and others. The panel will see that it says Eastern Cape, Makhanda, right at the top on page 1. So it's a judgment of the Makhanda High Court. But then I would love to refer the panel to paragraph 30 of the judgment at page 11 thereof. Paragraph 30, which I quote,
Yes, JP.
may I continue?
Yes.
Thank you, Chairperson. Paragraph 30, which I quote, this case is significant for all the parties involved. Some of the issues raised are novel. In light of this, a full court sitting as the court of first instance was constituted. In terms of Section 14(1)A of the Superior Courts Act 10 of 2013, sorry, it was constituted in terms of that section. Also, even though the case is justiciable before the High Court in Makhanda, for the sake of convenience, it was, with the consent of all the parties, heard in the High Court, Gqeberha. That is just the relevant paragraph I wish to make. And then the last point that I wish to make, right at the last page, on the last page rather, the last page is page 40. The matter was heard on 30 and 31 May 2022. For the sake of completeness, to the extent that there's reference to some conduct that I meted out to the complainant on 31 May, it places me, this judgment places me in Gqeberha. That's the only point I thought I should make, purely for the sake of completeness. And I'm thankful to the evidence leader for affording me the opportunity to do so. Thank you, Chairperson and honorable members.
Thank you. Advocate Skippers.
Thank you, Chair. What I've started to say was that we went through a lot of WhatsApp exchanges between yourself and the complainant. And you would agree with me that the only reason why we have those chats is because the complainant saved it on a phone and Mr. Moller could find it on her phone. It was not found in your phone, is that correct?
What was not found in my phone?
The WhatsApp chats that we have before the tribunal.
Yes, I remember the evidence of Mr. Moller.
And the only reason we have it is because the complainant saved it on her phone.
I hear what you're saying.
You dispute that you ever sent K8.
Correct.
And you base this fact because of the timestamp on the photo. And it does
Yes.
not correlate to any of the correspondences.
Yes, and I would like to, at this point, afford you the opportunity as I seek to answer your question so that I proffer a meaningful response to refer me to the time and date at which this annexure was sent. I've got the documents here. I will leave it to you to point me to that. The only way in which I can proffer a meaningful answer, I believe, is when, as part of your question, point me to the date and time at which I'm said to have sent that annexure.
The complainant testified that she received more than one picture of this nature. You heard the evidence.
I'm listening.
Correct?
I'm listening.
Due to the fact that so many messages have been deleted, and the time that has passed between the correspondence and us being here, it is possible that she could have made a mistake on when she received it. Is it true?
Could you please, ma'am, insofar as we are talking about K8, tell me when and at what time it was sent? Then I will answer.
That is what I'm putting to you.
No, I'm just
so
talking
many
about,
messages have been exchanged between the two of you. It is unfair for her to remember exactly when she received it because you have deleted messages.
I don't think you understand.
Advocate Pretorius, are you
Skippers.
Skippers? Are you unable to give him the date and the time?
The complainant is also unable. She cannot say.
So how is he going to defend himself?
Chair, we have to look at the evidence and we have to look at all the evidence before the tribunal. The fact is she testified she received it. The fact that she cannot pinpoint exactly when it was received is not the end of it all. We need to look at the probabilities. She has received more than one picture of this nature. She has testified like that. To say exactly when K8 was received is unfair because of the fact that the messages have been deleted. She could not go back and trace exactly where it was sent because of the messages being deleted in the chats. And unfortunately, she did not save a screenshot where we can see the date. We don't have that. I agree to that. We don't have that.
Chair, I'm going to object. We can't keep reconstructing a case. We can't keep reconstructing a case. The only fair thing is to tell my client you can't reconstruct a case now. And I'm talking to you, Chair, and the evidence leader. I just think it's unfair. This kind of litigation is unfair.
Yes, Advocate Skippers.
I'm only putting the version of the complainant to the respondent. He can comment on it, or you can choose not to comment on it.
Advocate
Judge
Skeepers.
President,
Yes.
they cannot tell when it was sent or what time it was sent.
Yes. In light of what you are saying then, I am saying to you the persistence in saying I sent K8 is crystallizing in the direction of being malicious, to the extent that insofar as you are putting that question to me, you yourself can't put time, can't apportion anything, and therefore I'm not able to proffer a meaningful answer. But beyond that, we know from Captain Botha, whose affidavit has been filed, that no such picture was found in my phone or in my handset. That's the first thing. We also know from the testimony that has been given here that it is unusual to get a situation where you've got 0905 on the bottom right-hand side. I thought maybe you were going to say, okay, it was 0905 on a certain date or around a certain date. In light thereof, then, I can't then proffer a meaningful answer. I disagree with the version. I dispute what is being pursued against me in the manner in which it is done. Thank you, Chairperson.
Captain Botha also did not find any of the WhatsApp messages on your phone because it was deleted.
I think you missed the point with due respect. His task was merely to unleash pictures, not chats. And
No, I disagree with you. His report clearly states that he needed to look at the WhatsApp chats as well as the pictures. He did not find anything.
No, as far as I know, his task was pertinently to check on pictures. He had a specific mandate in view of the fact that I have launched crimen injuria proceedings.
Even Mr. Moller did not find any WhatsApp chats on your phone because it was deleted.
His task was to check chats and not pictures, if I may remind you. Do you have the affidavit of Captain Botha with you?
I will deal with the questions, thank you. When she received her phone back, the complainant testified, when she received her phone back from SAPS after a death threat case has been opened because of death threats she received in the beginning. I'm not talking about now. She testified that she noticed that a number of things were missing from her phone, messages, conversations, as well as pictures.
I hear what you're saying.
So it is impossible for her to clearly construct when it was received because things were removed or missing from her phone.
No.
So it's unfair for her to recall exactly at what time and on what date that message was received.
Surely that can't be the position. That proposition flies in the face of reality based on everything, the objective facts that we have here. And also, I have no knowledge about her interaction with the police, in as much as I have no knowledge of any death threats.
If we look at K12 in volume 1, it is on page 51.
Volume 1.
Page 51.
Consolidated volume.
No,
1.
the one where the complaint is.
Thank
The
you.
initial volume 1.
Page
51.
51.
Yes.
Yes.
We're just waiting for the panel to get there.
I'll have to wait for the file. Bali and I couldn't get it.
Okay, skippers, on the issue of annexure K8, can we turn to page 18, which locates the date of K8, I think,
In the
in the
consolidated
consolidated bundle,
page?
page 18,
Which
18,
consolidated bundle
Consolidated.
of
page 18, Honorable
page
Member.
18. Page 18.
small 18.
Yes. Paragraph, page 19, my apology. Page 19. Page 19. It talks about annexure K8, but the date is found in page 18 to look like it was on the 20th of June. Would I be correct?
According to this statement, it can look like that, yes, because it follows on that. She did not put another date on that, and it looks like that's what she tried to convey in this paragraph, yes.
Thank you.
Thank you, Honorable Member. In light of what has been raised, we now have an inkling. It is 20 June, according to the statement made by the complainant under oath. Then, insofar as the question is important, could I then be told when on the 20th of June, so that I can assist, proffer an answer that is going to assist the panel to arrive at a conclusion?
We've already dealt with this. The complainant does not know at what time she received it.
But we've
It
got,
was on, during that conversation,
which one?
yours, please, on the 20th of June. She said that she did receive a picture of a penis, but I've put it to you that she has received more than one.
I'm still talking about Annexure K8.
Yes. She
Let
could
me
have made a
then-
mistake. Witnesses make mistakes, don't they?
Sorry, ma'am, I'm not arguing the case. I've got lawyers. You are lawyers for your part. But
We've dealt with K8. I'm happy with the answers on K8.
sorry, ma'am.
Do you want to deal with it further?
No, in light of what the honorable member, the member of the panel has said, now it seems there is a date, then the time of the conversation in 2150 was 2158, if I remember. So I don't understand the correlation between 0905 and 2258 rather.
We have dealt with that.
But
She has
why-
received more than one.
But why the persistence, ma'am, on Annexure 8 in light of what you're saying?
I'm
based
putting
on
the
sworn
complainant's version
testimony?
to you. That I'm not persisting it. I'm just putting the complainant's version to you.
Which is also, part of which is what is pointed to by the honorable member. Is that not so?
Can we move on?
Judge President, did you or did you not send K8
I did
to the
not.
respondent,
I did not.
to the complainant?
I did not.
Thank you.
Thank you.
Advocate Skipper.
Thank you. K12, page 51. That is a picture that the complainant uploaded on her status, and you say that it was not. You did not comment on this. This is not your reply.
K12 is not an embodiment of conversations between the complainant and I. Once again, through your indulgence, Chairperson and honorable members, I would like you to tell me when this conversation took place, for me then to assist.
I'm talking about the status. The date is there, 28 June 2022. That's a status that she uploaded on her phone. You deny that this is your reply. Can I finish my question?
Yes.
That is also the same picture that's on page 61, Annexure P. Is that correct?
Could we deal with one thing at a time?
Can I ask my questions, please?
No, ma'am, I'm confused because you are referring me to K12 at 51, and then you're also referring me to another.
Because it's the same picture. I'm referring you to what? Look at it.
To look at
Annexure
K12,
P. Annexure P. Look at Annexure P.
Annexure P. Yes.
That is the picture that's uploaded on her status.
I'm listening.
On page 61
Yes.
of the same volume that you are in, volume 1. Yes,
Page?
61. That is the picture that she uploaded on her status on K12.
I'm listening to what you're saying, ma'am.
She testified that you sent this picture to her
Let's-
on
could you-
Annexure P.
Could we start with K, because we're dealing with two pictures or 2 pages. The first one, let's deal with it. Did you say K12? Let me go back to K12.
I asked you, did you send Annexure P, the picture of the naked leg, to the complainant?
I did not.
Thank you. The complainant testified that she
Evidence
posted.
leader, sorry,
Say
ma'am.
again?
I'm sorry. The manner in which I'm being treated here is unacceptable to me. I say so because you refer to 2 pages, 2 annexures, and then when you pose a question, it relates to one particular page.
I'm going
am
to the
up-
other page now.
You referred me to K13 at page 51, and when I was trying to engage in relation to that, you jumped to another page. I'm confused.
Why are you confused? The reason why I showed you Annexure P was to show that that is the picture that she uploaded on her status. How can there be any confusion?
I did not send that picture.
Thank you.
That
That's
is
all
not
that I
my leg
asked.
in any event.
That is all that I asked. Can we go to K12 now?
Thank you.
On 28 June 2022, the complainant uploaded this on her status. You don't know about that according to your version. And she said that that was a photo. She testified that that was a photo that she received from you. You say you did not send that photo.
I did not, but then I need to pose a question. When and what and at what time? Let's go to K12. Let's hear what she has to say about K12. This exercise we have to go through. We can't just skim through. This is a very important aspect of the case. K12. Reference to K12 is to 28 June at paragraph 17 of paragraph 17, consolidated. Maybe because we are dealing with volume 1, let's rather deal with page 9 of volume 1. So far, according to the complaint that is serving before this tribunal, based on the sworn testimony of the complainant at paragraph 17, she is alluding to facts or things that she says took place on 27 and 28 July. So I am simply saying to you that incongruity is staring at us, regrettably. So you are mentioning 27 June 2021. There's no correlation with 22 June 2022. Could I repeat myself?
You don't have to repeat yourself.
I've
The
made
complainant testified that that was a typing error. That question was put to her
Where is the typing error?
on the year.
On
She
the-
said it was 2022 and not 2021. She testified on that.
So there's a conversation, according to what you are saying, between the complainant and I on 22 June 2022. Is that what you're saying?
27 June 2022.
27 June 2022. So
That's
then it means,
paragraph 17 in the complaint.
yes,
She testified when she was cross-examined on that.
yeah.
She said that that was a typing error in her statement. It should have read 2022.
She's untruthful. The incongruity is staring at us. In fact, even the suggestion that something happened on 27 and 28 flies in the face of the report that we were given by Mr. Moller. There were no conversations on 27 June and that other date, 28. So I dispute what the complainant is saying. I dispute the suggestion made that that was a conversation involving the complainant and I.
If we go back to K12, page 51, the
Yes.
complainant testified that she uploaded this picture on her status because she was now extremely tired with your inappropriate sexualized communication and did not know what else to do.
She's lying.
She described this as a cry for help, a way of saying, and this is what she also said, here I am, being sent inappropriate content by someone older, someone who holds power over me, even someone's husband. Did you consider how that conduct made her feel?
She is lying.
Ms. Ngapi, can we maybe on page 51, do you have that page?
I only have volume 3 file in front of me.
If we can just get the translation of the last.
What's the page?
Page 51.
51. This is 50. All right, I'm on page 51.
The message with the status, what is the translation of the words there?
Is it the message on the 28th of June, 2022?
Correct?
All right. Umyeni womntu utata wabantwana abadala abe ngumphathi aphinde. All right. This is the direct translation. Someone's husband, a father to children that are older, and again, he is a manager or leader,
And we don't have the rest.
and then the rest, it's aphinde, then again, he, but there's nothing further that's written on the actual picture.
Is the translation we got the previous time was adult children. Would that also fit in?
Is adult or older children, makes sense.
So the complainant testified that that was her cry for help.
I dispute the version of the complainant. To add more on what I believe should be, to add more on what I would like to say in relation to this. If you look at the language, if she would have had the audacity to address me in that fashion, then it says a lot about her.
If we can go to Annexure N, that is on page 58 of volume 1.
58. Got it?
Do you recognize that picture?
Correct.
Is that your picture?
Correct.
Do you know where the complainant got this picture?
I addressed that in my answering affidavit. It was my status picture at some point. She told us how and what she did about it.
This picture, we see that the date on this picture is 27 May. We don't have the year on this picture.
Come
So-
again? We don't have what?
The year, it's not depicted here. It's only saying 27 May on top.
I'm listening to you.
So you made mention of the paragraph in her complaint that says you sent her this picture on 31 May.
No, you missed the point. Let's go back to what I said. I was addressing 31 May 2022.
Oh, that was with regards to the walking.
Yes.
Okay. Sorry. So she said in a complaint that you sent this message to her and you were at the NEEC meeting, according to what you testified
The
yesterday.
NEEC meeting was on the 26th. I flew back to East London on the 27th.
27th.
Yes.
So that is why you say you couldn't have sent it to her.
Not just that. The starting point is that this was my status picture. That's why you see it's got you. It means she uploaded it, in my view, and then made it her picture. And then this is how it got to be what she alleges happened.
What she testified, what happened is you sent her this message. She saved that photo, wrote the words no comment on the bottom, and forwarded it to Brenda. And that is where she took the screenshot from. It's not
Send,
from the chats that you sent to her, it's from the chats she forwarded to Brenda.
when am I said to have sent this picture to the complainant? On what date and at what time?
The 27th of May. The fact that you were not in your office does not mean you could not have sent it to her.
But that's not what she says in her affidavit.
Do you agree? The fact that you were not in your office does not mean that you could not have sent it to her.
I'm saying the proposition you are making is predicated on falsity, demonstrably. Because she says, I was in Umtata, I sent it whilst I was there. In her affidavit, under oath.
You could have sent it from Johannesburg, could you not? You could have had this picture on your phone and forwarded it to her. Is that correct?
Is that what you are saying to me? Which is contrary to what is said by the
We are
complainant.
looking into probabilities.
I disagree with your proposition.
Thank you.
Advocate Skeppers, if the complainant says that he sent it while he was in Umtata, on what basis do you then say to him that you could have sent it from Johannesburg?
I hear the chair. The fact is,
You see, Advocate Skakani said that we can't keep on reconstructing the case. You have no reason to say when your client under oath says he sent it from Tata, for you then to come and say, oh, you could have sent it from Johannesburg. That's not how things work.
thank you, Chair. I will move on to the 14th or 15th November. You gave a detailed explanation of why you were in Tata on the 14th November 2022.
Correct?
It has never been in dispute that you were present in Tata in 2022 on the 14th and the 15th of November.
Absolutely correct.
The issue before the tribunal is not whether you were in Tata, but whether or not you behaved indecently towards Ms. Mbenenge on that day, which she refers to as the unzipping of the pants incident.
I agree with what you're saying.
And you referred us to the afternoon video footage and pointed out that Ms. Mbenenge was not seen walking past your office that day, and that is why you say that it could not have happened.
I am saying, from what we saw, and based on what she said in her affidavit, there's an incongruity. She says she walked down from the direction of her judge's chambers towards my chambers. And then that is when this alleged incident that is being persisted in, that is when it occurred. Then she said she came back. That does not find support from the video.
We don't have the full day's video. You agree with that?
I hear what you're saying. I know nothing about videos. All I know is they're supposed to be there.
The fact of the matter is, what I'm putting to you is, the fact that it's not on the video does not mean it did not happen, because we don't have the full day's video footage.
I don't know what you're talking about, ma'am. I'll tell you why I say I don't know what you're talking about. The proposition is that this is something that occurred. I'm still grappling with the date and time. And I think everybody here knows why I am grappling with that. But for purposes of the debate now, or the engagement, you are saying, forget about what she said in the affidavit. It occurred on the 14th in the afternoon. And then there's a video. That video has got a view, a perspective. I'm saying that perspective does not even find support from her allegations in the affidavit. That is the statement she made under oath, even assuming that something of that nature occurred on the 14th. So I don't know how many times I must say this. It is not correct. It is not truth. The persistence with this, in my view, can only be malicious.
I'm testing what you testified yesterday. You said that it could not have happened because it's not on the video footage of the afternoon. And I'm pointing out to you that we don't have the full afternoon's video footage. That's all I'm saying. I'm not going into anything further.
No, we've got to engage one another on this because a question must be predicated on something. And it must, among other things, be predicated on what she has said under oath, which has resulted in all of us being here. That is why I'm engaging you in this fashion. The version of the complainant is denied insofar as she says this about me, be it on 15 or 14. I've already made myself very clear. We can repeat this for 100 times, it is not going to change. All I'm going to say is this is becoming highly malicious.
We also don't have the video footage of the other corridor. You going the corridor where your Mbenenge Zintles office door is. We don't have that corridor's footage.
Are you telling me
Yes.
that that is the position?
We don't have that footage. You agree with that?
Well, what I saw on that day depicts exactly that. It depicts what you are saying, but it doesn't alter the position insofar as the testimony tendered by the complainant herself, saying that she walked down and immediately thereafter she walked back. Exhibit 5 also negates this suggestion. That is persisted in, maybe for the 200th time. It is malicious, ma'am.
But that's my point. We don't have the full day's video footage.
I've answered you.
Shall we move on, please?
Yes, thank you, Chair.
If there are further questions.
Your secretary also confirmed the complainant's evidence about the fact that regardless of your reliance on the tracker of the vehicle and your general whereabouts, there is no conclusive proof before this tribunal that the incident in your office did not occur.
I don't follow the question.
The fact that you wanted to pursue the tracker
Which
And the-
tracker?
of your vehicle
Yes, thank you.
and your general whereabouts does not say that the incident could not have occurred. There are many times that you were in your office when your secretary was not there during the day of the 14th.
Your proposition fails. Let, in the face of objective facts that we have, let's start with the 15th. I have to start there because according to the complaint, that is when it is said to have occurred. On my own, without the assistance of the evidence leader, in an inquisitorial situation or investigation, I set out to uplift the tracker of the 15th on the basis that I am said to have meted out this conduct on the 15th in the afternoon. And in keeping with what I said in my affidavit, lo and behold, I was not there in the afternoon of the 15th. It makes it clear that I got to chambers around 9 o'clock, I left around 12 o'clock. That is the first point that I wish to make. So I take umbrage to any suggestion that I'm trifling with this tribunal insofar as I'm placing facts, objective facts that are supposed to assist the tribunal. The same goes for the 14th. The evidence leader in an inquisitorial system is told that there is somebody who can provide information about a tracker. And then I place that report against the background that I gave a day or two ago. The persistence in these questions, I repeat, is malicious. I deny what you are suggesting. We can repeat it 100 times, ma'am. I'm not going to change my version to suit how you feel, couldn't, and the probabilities that you are trying to build. Thank you, Chairperson.
I put it to you that the incident Ms. Mbenenge describes of you unzipping your pants could very well have occurred during one of those unaccounted for periods in the afternoon when your secretary was not in the office and also when we do not have the video footage.
What time was that?
Just answer the question, please.
I can't answer a question.
It could
that
have happened.
It did not happen. The issue is whether it happened. It did not happen. And on the objective facts that we have thus far, I think it's demonstrably clear that it did not happen. You can repeat this 200 times. it's not going to change the situation. This is becoming malicious.
You also testified that you anticipated a possible sexual relationship developing with Ms. Mbenenge when you had interest in her.
Come again?
You testified when you started testifying that you developed an interest in a sexual relationship with the complainant.
Did I mention sexual relationship?
Yes, when I prompted you, you said that it could have led to that. So that was part
You
of
are
it.
now putting it correctly. It could have led to that.
Exactly.
Yes, but it was a flirtatious interaction.
And you also asked her, can we be intimate in the WhatsApp
Indeed.
chats? Indeed. So in
Yes.
light of your own admission and the surrounding evidence, it could have been probable for her that that her version is correct, that you exposed your penis and asked her, do you see the effect you have on me?
Ma'am, are you repeating this now for the 300th time?
Why are you constructing such a probability on disputed facts?
I must put the probabilities in the complainant's version to the...
Probabilities are a combination of your seeing of things, which must be reserved for argument.
I will leave it for argument, Chair. In your evidence yesterday, you stated that nothing occurred between February and November 2022, and that is why you believe this November incident was added later to embellish the complainant. Essentially to make the WhatsApp chats more serious than it really was. Do I understand you correctly? Is that what you said?
It's part of my submissions insofar as, or part of my answers. But let's go back to the transcript of 14 January 2024. 14 January 2024. Counsel,
I'm just trying to get there.
thank you. I just want to mention something from the perspective of the complainant within the context of the question that you are posing. Then at page 10 of the evidence that was led on 14 January 2024 before this honorable tribunal, paragraph 10, sorry, line 10, 11, 12, 13. As a girl, if there's someone who knows, who shows interest in you, you propose. So the complainant herself,
Sorry, you proposed is not there.
no, it is there. Now I am in isiZulu because I almost said something else. You propose.
All
Miss
right.
Ngapi says that.
Yes, it is correct that you
Thank
state
you.
it now, yes.
Then she goes further. He must come out crystal clear as to the reason why he requested my picture. So in other words, the complainant, the stance of the complainant is that, forgetting about my status, this man must come out clean. If he is proposing me as a girl, I'm ready.
You did not answer my question.
I
You
answered
said
your
that
question. I answered your question by saying the version of the complainant is not correct. The one that you are articulating in the fashion in which you are doing.
I need to test what you said yesterday. You said that the incident of the 14th of November was added later to embellish the complaint.
Yes, you also said it's a matter for argument. You are persisting with this. Please don't.
The complainant testified in her oral evidence that after lodging the complaint and receiving death threats, she handed the phone over to the police. I already put this to you. When it was returned, several items, including messages and pictures, was missing. And then furthermore, under cross-examination, on the 20th of January 2025, from page 55 of the transcript onwards, she explained that the reason the 27 June date, and I'm now going back to that K8, K12, was not reflected in the 2021 message thread is because you actually sent that message in 2022 and that she made an error with the date in paragraph 9. I'm just pointing to you towards where it is in the transcripts. That she said that it was a typing error. Then she went on to testify that she tried over time to navigate your repeated unwanted messages as she best could. But the incident in November 22 was, as she put it, the point at which she could no longer tolerate your conduct. That is why the complaint was laid after the November incident. Not because she wanted to embellish the WhatsApps.
It seems to me that that's a matter for argument. But insofar as you are seeking my comment, I repeat what I said earlier on about her version.
Why did you cancel the roundtable discussion that the complainant requested through Mr. Krokwana?
Shall we go to the consolidated version? Sorry, the consolidated record. Insofar as it embodies my response, just by way of reminding, that is the affidavit that served before the JCC. Ma'am, you may assist me. I'm looking for the affidavit that I deposed to, which served before the JCC. Consolidated bundle.
It's 69.
Number?
It's page 69 of the consolidated.
Page 69. Thank you very
Small
much.
69. It starts there.
It starts at page 69, and what I wish to refer to is my version, which I cling to in relation to why, if I may get assistance, I'm going for, oh, sorry, it's actually starting with the complainant's version herself, set out in her affidavit in relation to what the purpose of the meeting was, according to her. If the chairperson can bear with me, it is very important for me to locate this. It's page 22 of the consolidated bundle. I'm going to read paragraph 23. It's page 22 of the consolidated bundle. I'm going to read paragraph 23, particularly the last sentence. Quote, I wanted a strategy to deal with the problem with the intention to stop the trend so I may produce evidence. Stop, close quote. So we are told what the motive of the meeting was. And the question is still posed by you, counsel. It's fine, so be it. But in response thereto, I dealt with that. I said I could never, in my sound and sober senses, attend a meeting where I'm going to be confronted with pictures that I say I never transmitted to the complainant. I hope you remember that, what I said in my affidavit. Let me locate it. We are moving now from the premise that under oath, she tells this tribunal. I'm saying so because that is her complaint that served before the JCC. The terms of reference of this tribunal, evidence from me. It was a stratagem. She was not very genuine. Be that as it may, I am going to look for the spot where I am dealing with this, insofar as I say why I did not attend that meeting.
I think it's page 86.
Page 86. Thank you, counsel. Paragraph
35.
35. Shall I start with page 86? Shall I start with paragraph 34? I was initially amenable to attending the meeting, but on further reflection did not see the purpose in attending a meeting where I would be confronted with pictures that I had no knowledge of, more so in the presence of other persons. May I continue?
Yes.
I found it disconcerting to learn that the subject of the meeting was two pictures which I bore no knowledge of. I was unable to fathom why Ms. Mengo would, in those circumstances, want to confront me with these pictures. This, in the background of what she said, if you read these things together, then I'm saying to you, I could not attend that meeting. And thanks God I did not.
That was just a normal question. I don't know why you are so defensive. This tribunal has not heard your version. We only heard the version from Mr. Krokwana and the complainant. That's why I afforded you the opportunity. Why did you cancel it?
No, ma'am. I'm saying there is a version
Yeah, but you
already.
have not testified on that. I gave you the opportunity now to say why you did not attend the meeting and why you cancelled it.
You move from the premise that I'm being defensive. I am not defensive. This word suggests something, it's pregnant with meaning. Be that as it may, I believe it was important for me to start at that point where I say to you, you know much as I do, why the complainant wanted this meeting. Or you ought reasonably to have known, because it is contained in her very complaint. And therefore, I could not attend that meeting. I did not. I don't regret that I did not.
But you did not take further steps after you cancelled it.
Further
Because
steps,
the complaint was made soon thereafter. Is that
further
correct?
steps to do what?
To clear the air between the two of you.
I did.
What did you do?
I tried calling her on Sunday
But she blocked you.
correctly. I'm sorry, correct. That's what she did. Thank you for reminding me.
So, other than that, you did not do anything else.
What else could I do
I'm just asking.
than move around and say to people who might know her, I am gutted by her step of putting conversations that are supposed to be private between the two of us only. Please prevail on her to desist with this conduct of posting these things. And I believe one of the witnesses did mention that.
Then, after,
Then that was an issue about reconciliation. I just could not understand. I was actually gutted. And I say as much in the affidavit, which I believe you have seen.
and then that I think you are talking about Mr. Krokwana's evidence.
Not just Mr. Kokwana's evidence, and I think Mr. Abongile Shete.
Mr. Krokwana testified that he did indicate to the complainant that you say that she's lying and that's why the roundtable cannot proceed. And you say that that is indeed what you said, why you cancelled it.
That is not only what Mr. Kokwana said. Mr. Kokwana actually was taken through my testimony embodied in the affidavit, and she confirmed why, in his view, the meeting aborted.
Yes,
The reconciliation meeting that
I'm getting there. I'm taking it point by point, otherwise you say I asked a long question.
Thank you.
And then because of that, the complainant then placed the WhatsApp messages on her status. That was also what Mr. Krokwana said. And that is why he then aborted it and referred it to the OCJ. Is that correct?
Who referred what?
Mr. Krokwana referred this issue to the OCJ.
I don't dispute Mr. Kokwana's evidence insofar as his reason for then escalating the matter, the manner in which he put it, and insofar as he confirmed my version, which was put to him by my counsel, Mr. Madonsela.
And that is also when all these WhatsApp messages became known to everyone because it was now on social media.
It was also on the media.
WhatsApp status is also social media.
Not just that, it was in the Daily Dispatch. I'm still gutted.
So it was known everywhere.
It was known everywhere insofar as people have had access
Yes.
to the media.
The screenshots that she uploaded, that's what I'm talking about. Not the fact that whether or not it is true, but what she placed on the WhatsApp statuses was known.
Yes, indeed, some of which is a conflation. We now know when we compare what we have as the complaint and what was withheld. And to the extent that I thought it was a criminal offense for one to disclose things between two persons. And I just felt that some person should prevail on her. I was gutted by what the Daily Dispatch did at the instance of the journalist that I earlier referred to.
I'm going to ask you just a few concluding questions.
Thank you.
The complainant said that when she was asked about your conversation at page 1223 in volume 3, that made her feel like a dirty person. I already put that to you yesterday. How does it make you feel that someone thought that you were having what you call a consensual relationship with describes as making her feel dirty?
Come again?
How does it make you feel that the chats that you thought was consensual,
Yes.
she tells the tribunal that it made her feel dirty?
So what is the question?
What do you say about her version?
It's a reconstruction, it's lies. I answered that question yesterday. At least the purport of my answer is before the tribunal already.
So if I understand you correctly, given everything that has unfolded here before the tribunal, your messages, the language that you used, and the nature of the interactions, you've stated that you didn't believe that your conduct was unwelcome at the time.
I repeat everything that I said in chief and what I said yesterday. I still repeat it now.
So if that is your view, if you have an interest in another secretary, would you then continue the way you WhatsApp Ms. Mbenenge with that secretary as well?
You
I don't
have to-
follow the
you're
question.
Sorry, you don't have to answer that.
Thank you
question.
very much, Chairperson.
Thank you, Chair. I have no further questions.
Thank you. Advocate Sikakane.
Thank you, Chair. We will do no re-exam on this cross-examination. The next issue I wanted to raise with the panel is that my attorney would like us to revisit the issue of dates from now on, just in chambers. But that's
To do
all.
what? Sorry.
To revisit the issue of dates, exchange of heads of argument, and all of that. But just it's a discussion in chambers we can have. Yes, yes. But we have no re-examination to do. Thank you.
Uh, JP, thank you for your time. You are excused.
I thank you, honorable members. I thank all the role players here. Thank you very much.
Um, Advocate Sikakane,
Thank you, Chair. Chair.
are you closing your case?
Our case rests here. We will call no further witnesses. My attorney tells me that in relation to other witnesses or a witness, I think they did reach some rapprochement with the evidence leader. So we will call no with this.
All right.
Our case rests here.
Evidence having been concluded, the matter is adjourned. Thank you.
Thank you, Chair.